Welcome to No Apologies. I'm Dana Lash. So as I've said, what was actually on trial and what is on trial with Kyle Rittenhouse, it's not just Kyle Rittenhouse, but it's also your right of self-defense. The progressive left, if they were honest, would just admit that they don't believe in the right to self-defense, including the right to protect yourself with a firearm. They don't like that people own firearms, and this is the perspective through which the MSNBC and CNN types view this case. The facts of the case are irrelevant to the legacy press and the left, because the goal is to make you feel that self-defense isn't even an option for you. And this is why even today, after it was made very well known that Rittenhouse lives in Antioch, Illinois, with his mother and sister just 20 minutes over the invisible state line between Illinois and Wisconsin, and that his dad and grandmother live in Kenosha, that Rittenhouse works in Kenosha, and his rifle is in Kenosha, and in fact never left Kenosha, the media and many in the commentariat still insist that Rittenhouse drove with a quote-unquote assault rifle for hours across state lines. The state's case has been a total clown show. It's been a fecal storm. The prosecutors are the real-life legal versions of Brendan Huff and Dale Doback from Step Brothers. It's a true story. It's the Step Brothers law firm. All Assistant DA Thomas Binger and James Krause had to do is establish a reasonable doubt in the minds of the jury that Rittenhouse is the aggressor who did not act in defense of his life. So that's why you saw arguments like this one.
Convince you that Joseph Rosenbaum was going to take that gun and use it on the defendant because they know you can't claim self-defense against an unarmed man like this. You lose the right to self-defense when you're the one who brought the gun, when you're the one creating the danger, when you're the one provoking other people.
Oh my gosh, wrong. So according to Thomas Binger, did you know that if you have a firearm, you can't use it in self-defense unless your attacker also has his own firearm, especially when you're defending yourself at a riot? Did you know that? Because that's exactly what the prosecution just said. Binger is making stuff up. Now, apparently, the prosecution had no problem with Gage Grosskreutz illegally carrying his Glock on an expired license. Also, Prosecutor Binger didn't see an issue with Joseph Rosenbaum, the convicted child rapist, like 5 years old. We're not exaggerating. He was released from a mental ward and went straight to the riot, where he screamed racial slurs and swung a chain, threatened people, and tried to burn down 2 separate businesses. Rosenbaum got mad at Rittenhouse because Rittenhouse helped to extinguish a dumpster fire that Rosenbaum had started in an effort to blow up a gas station. Here's head prosecutorial clown Binger downplaying Joseph Rosenbaum's actions that night. Watch this.
Oh, let me tell you all the awful things Joseph Rosenbaum did. He tipped over a porta potty that had no one in it. He swung a chain. He lit a metal garbage dumpster on fire. Oh, and there's this empty wooden flatbed trailer that they pulled out in the middle of the road, and they tipped it over to stop some bearcats, and they lit it on fire. Oh, and he said some bad words. He said the N-word.
Imagine that's your job. You wake up and your name's Thomas Binger, and you have to defend a child-raping racist. Imagine that's your life. Gotta love how racial slurs are suddenly no big deal to say, according to the prosecution. They're apparently fine with everything child rapist Rosenbaum did that night. And he left out some things, though, like, I don't know, maybe including participating in a riot that burned down Black-owned businesses right after Rosenbaum was released from the mental institution? Or what about how he left out what the medical examiner had testified to when he grabbed the barrel of Rittenhouse's gun? That's what started this whole thing in the first place. Rosenbaum was mad that his little fire got put out, so he was chasing Kyle Rittenhouse, and according to the medical examiner, his injuries were absolutely 1,000% consistent with someone who grabbed the barrel of a rifle, which technically he wasn't unarmed at that point. The prosecution took their idiocy up a notch with theatrics when Binger poorly shouldered the rifle in question and flagged everyone in the courtroom while his finger was on the trigger and his chicken wings sticking out. This is how to handle the rifle in the most irresponsible Alec Baldwin way possible. Finger on the trigger, flagging the courtroom and jury, All of this, a cornucopia of examples. I would have loved to have seen the jury's reaction to this. He was trying to scare them. This is theatrics. This is so stupid. I'm actually surprised the bailiff didn't intervene. I'm actually shocked the judge himself didn't object to this and stop the proceedings and then maybe call Binger up and say, there's maybe a more responsible way to do this. Prosecution also asked why Rittenhouse didn't commit the crime of just firing randomly, indiscriminately into the air within city limits, or just drop the gun, for which Rittenhouse would have been held responsible when one of the convicted criminals pursuing him murdered an innocent with it. No joke, they argued this. Watch.
He could have stayed at Mr. Rosenbaum's body, helped protect him, helped preserve his life, call 911. As he's running, he could have announced to the crowd exactly what he was doing, told them. He could have fired warning shots to try and keep him away. He could have dropped the gun. He could have raised his hands in surrender. He could have signaled to this crowd that he did not pose a threat anymore.
You mean like when he yelled friendly, friendly, medic, medic, friendly, friendly, over and over and over and over again like that? And Rosenbaum heard because he was in that vicinity? Yeah, I don't think that worked. By the way, what an moronic, everything he's telling him here, that's illegal. You can't just fire a gun in the air. Where do the bullets go, Binger? They just disappear into the ether, like fireworks. That's where fireworks come from. Rittenhouse also tried surrendering, by the way, to police immediately by approaching with his hand raised, all on video, but the police did not detain him. In fact, he had to turn around the next day, and he turned himself in Illinois. There was this, Jim, too, also from a member of the prosecution. Watch this.
Guns do not have handed. There's not a left-handed or right-handed gun.
Yes, there are left-handed and right-handed firearms. Someone tells Stag Arms, apparently, that some of the stuff that they make doesn't exist, or that, shock. I mean, anybody who's ever, like if you're right-handed and you're firing something that's meant for a left-handed person, pretty quick when you got the safety and some of the control mechanisms on the wrong side where they would be for you, and you have hot brass flying in your face. That's also a big thing. You would think that the prosecution would have maybe brought in a firearms expert. I just think that if you're going to be talking about a tool in a case, then maybe you should know a little bit of something about it. But then the prosecution knew that if they did that, they couldn't just make stuff up out of the ether. But you know what? The truth is, Kyle Rittenhouse should have fought off the mob with his bare fists, the prosecution says. Imagine trying to fight a mob like this with your fists. You can't fight off a mob with your fists because it's your one pair of fists versus many pairs of fists. Now, to go further, speaking of fists, FBI uniform crime reports, and this is data on crimes committed by year, the demographics, it includes demographics of criminals, victims, location, the tools used, and homicides committed. Note that between collectively 2015 and 2019, homicides committed using hands, feet, and fists doubled more than, actually, they were more than double in some, and more than double in some years, homicides committed with the exact type of semi-automatic rifle that Kyle Rittenhouse used in self-defense. I think in 2019 alone, it was something to the effect of 306 with a rifle, and it was something like 600 with hands, feet, and fists. So keep that in mind. And remember, once again, all of this began because Rittenhouse, along with another armed civilian, they extinguished a dumpster fire started by a convicted pedophile, Joseph Rosenbaum, who then started pursuing Rittenhouse out of anger because they put out his fire. He was going to blow up a gas station and tell the man. Now, in August of last year, there was another man who tried to extinguish a fire. This is in August 2020. This is hard to watch, but you need to watch it. Rioters, this is in Kenosha, they tried to burn down an elderly man's business. And when he came out with a fire extinguisher to put out the fire and chase away the arsonists, he was hit from behind and he fell, cracked open his head on the building's steps. That's awful. This man, at one of the riots, August of 2020, that's what happens when you're unarmed. Kyle Rittenhouse would be dead today if he wasn't armed. Here's the prosecution actually making the case that if Kyle Rittenhouse had any courage, he would have just punched his way out of Kenosha like a Jackie Chan movie. Kyle, and speaking of fists, his fist versus 20 or 30 rioters. You had skateboards. Someone else had, Joshua Zeminski had a gun. You had Gage Groskowitz with his gun. Listen to this.
He brought a gun to a fist fight. And he was too cowardly to use his own fist to fight his way out. He has to start shooting.
That's carbohydrate fan James Krause, who thinks that, apparently you are a coward if you don't use your fist. I'm really curious as to what Krause would say to women who feel that firearms are our equalizer. Theirs is the case that you make when you have no case, when your real case is putting America's right to self-defense on trial. So you pretend that criminals and pedophiles who show up in small-town Wisconsin to create mayhem and burn down black-owned businesses are heroes. Rittenhouse refused to be a victim, and he used the most malign firearm in the country to defend himself, all of which challenges big tyranny's narrative on self-defense and semi-automatic rifles, so they got to destroy him. And it's not just him they want to go after, though. They want to destroy the will of any American to defend themselves with a firearm. They're trying to set the precedent that Americans should cower in the face of a mob. And the press is rooting this on, truth be damned. And that's expected because, they're Marxists and they promote the narrative. Even the president himself has been really busy front-running this verdict, calling Kyle Rittenhouse a white supremacist last year in a campaign video. Now, Peter Doocy, the ever-present thorn in the side of Jen Psaki, White House spokesperson, asked Psaki about this yesterday. Watch.
Why did President Biden suggest that Kyle Rittenhouse on trial in Kenosha is a white supremacist?
So, Peter, what I'm not going to speak to right now is anything about an ongoing trial, nor the president's past comments. What I can reiterate for you is the president's view that we shouldn't have, broadly speaking, vigilantes patrolling our communities with assault weapons. We shouldn't have opportunists corrupting peaceful protests by rioting and burning down the communities they claim to represent anywhere in the country. As you know, closing arguments in this particular case, which I'm not speaking to, I'm just making broad comments about his own view. There's an ongoing trial. We're awaiting a verdict. Beyond that, I'm not going to speak to any individuals or this case.
Psaki won't speak to Biden's tweet, but I will. Kyle Rittenhouse isn't a vigilante. He's a teenager who showed up to defend a neighborhood from being burned when actually it was a business, not even a neighborhood. And imagine, what situation is this country in when the police are barred from doing their job and a 17-year-old feels the need to go out and do this? That's a completely separate story from his right of self-defense. But I will say this, if Wisconsin's governor had done his job and activated the guard ahead of that fateful August night like he's done ahead of this verdict, we would know Kyle Rittenhouse's name today. And I'm sure as hell not going to be lectured about the vigilantism of Rittenhouse by people who ignore the for certain riots that will take place if he's acquitted, which is a huge possibility. Watch this video from a protest today.
Hey, how many cars are you guys gonna up tonight? Hey, how many cars are the BLM gonna up tonight? Hey, I got something for you.
There's like an endless stream of white criminal suspects who just want to burn stuff down. Are we surprised when the White House talks so recklessly about a case like this? How presidential is it for a president to shade a situation like this before the trial even takes place? Biden did, though. Remember when he was a candidate in September, he inferred that Rittenhouse is a white supremacist. By doing so, he added to that powder keg in this country. But worse, it reinforces a narrative that's a total lie. How is Rittenhouse a white supremacist when the white racial slur screaming pedophiles, domestic abusers, and burglars are the ones in the streets burning black-owned businesses? They're all white. The media wants to perpetuate this narrative that defending yourself with a firearm is wrong, and just for good measure, they add "and racist" onto it because they don't have anything else. That's the exact same logic Democrats used to disarm free men and women during Reconstruction. Racist old Democrats, some things never change. To lie about what happened in this case is to take the side of some truly reprehensible people. And yet they do so, and they demonize law-abiding citizens who rely upon firearms for their defense. So that's their narrative. And Biden and Psaki and the legacy state media and the prosecution are sticking to it. But the question is, will the jury buy it? So coming up, we're going to continue our coverage of the trial of Kyle Rittenhouse. We're also going to get an update from our friend and attorney, Guy Relford. We've talked to him before, and we're going to ask him about a development that took place just this afternoon when the jury came in and asked for when the foreman had asked for additional copies of pages 1 through 6 of the judge's instructions. And those pages, as we learned, have to do specifically with that self-defense privilege. We're going to ask Attorney Guy Relford coming up next. Stay with us. You have homeowners insurance for a good reason, because without it, a fire, flood, or burglary could destroy you financially. But there's another major crime that your homeowner's policy doesn't cover, and it's called home title fraud. Law enforcement calls title fraud one of the fastest growing crimes, and it can ruin you financially. This is why you need Home Title Lock. Title fraud happens when a criminal forges your signature on documents stating that you sold your home to them and takes out loans on your home, leaving you with the payments. You spend a fortune in legal fees trying to prove that you didn't commit fraud. Home Title Lock puts a barrier around your home's title, and the instant they detect anyone, cyber thief, renter, or relative trying to forge their way into your home's title, they help shut it down. Visit HometitleLock.com, register your address to see if you could potentially be a victim, and enter code RADIO for 30 free days of protection. That's code RADIO at HometitleLock.com. Welcome back to No Apologies. So last week we featured CEO and founder of the Second Amendment Project, Guy Relford, to give his in-trial analysis. And Guy, of course, is an attorney. He's had some pretty high-profile cases similar to that of Rittenhouse. Now, we promised that we would bring Guy back for more updates, and he's being very generous with his time. And so he joins us now, Guy Relford. As always, Guy, thanks so much for joining us.
It's great to see you again, Dana.
Of course. Okay, so everyone's speculating on this case. I mean, to people like you and I think a lot of other people out there, I mean, for us, it's kind of open and closed. We're not exactly sure what the jury is dealing with, but one of the developments that we learned this afternoon is that the jury had asked for additional copies of pages 1 through 6 of the judge's instructions. And those pages, as we understand, have to deal with the self-defense privilege and also Joseph Rosenbaum and intent to kill. Does that indicate anything to you? What is your takeaway from that?
Well, it indicates what they were thinking about in that moment. In other words, that was very soon after they retired to deliberate. So their focus very quickly is on self-defense. And the debate that happened yesterday before final arguments, I think, is germane to this discussion because the defense team was asking the judge to make an instruction that said, listen, even if you find all the elements of a crime is present, if you find that Rittenhouse acted in justifiable self-defense, you're done, and you don't have to consider anything more about that count. And so he gave them a shortcut and an appropriate one, and one that was correct under the law of self-defense, to say, look, you don't have to consider lesser included offenses. You don't have to go any farther. If you find he acted in justifiable self-defense, you're done. And so that gave me some indication that they may be looking to take that shortcut on each of the 5 counts.
Ooh, interesting, because I know some people, there was a lot of speculation from non-lawyers, people like me. I get a little nervous if it's not, I have an expectation when I'm paying attention and watching everything very closely to a trial, which I don't always do. And so normally I don't have such a hardened opinion, a formed opinion like this. But from all the video and the testimony, it makes it, a lot of people were speculating, gosh, if this goes on longer, does that indicate a hung jury? Is that what that's indicative of? And I know that I'm asking you to look at a crystal ball, but how long do you anticipate this going? And does that signal maybe a hung jury or something like that to you the longer this goes on?
Well, I think it's true that the faster they come back, if they in fact reach a unanimous verdict, the better news that is for the defendant, for Kyle Rittenhouse. The longer they go, it does certainly add to the likelihood of a hung jury, but I would go several days before I get over concerned about that. And the reason for that is because this is a 12-person jury. And a lot of states, including my Indiana, in state court have gone to 6-person juries. One, because it's hard to find people to serve as jurors. And secondly, because it's hard to get 12 people to agree on anything, including the lunch menu, much less a lot of complicated facts involving testimony and evidence from a lot of different sources. So the fact that there are 12 people that have to reach a unanimous verdict, it just means it generally takes some time. And some juries too, and I've seen this in my cases, where they go days and you start getting nervous, you start thinking about a hung jury. And then in a lot of cases, judges will let you talk to jurors after a trial is over. And it turns out all they did is they decided, because they wanted to be thorough and they wanted to be responsible jurors, they decided to take each piece of evidence and each witness and go through them and talk about them and evaluate and discuss how they felt about each piece of evidence, and then turn to the legal issues and the jury instructions, then apply the law to the facts, and then reach a decision. So sometimes juries just decide to be very deliberate and I think very thorough, and that's not a bad thing. And I think that's not a bad thing in this case. They also easily could get caught up in a discussion, for instance, of sort of the changing theories of the prosecution in this case. I watched all of the prosecution closing argument yesterday, and I had watched the opening statements as well. And what was interesting is, and the defense pointed this out, in the opening statements, the prosecution never talked about provocation. And that is the legal argument that if you provoke unlawful action against you, you lose the right to self-defense. It was interesting that that never came up in the opening statements, but suddenly it was really the crux. It was the main argument, the principal argument made by the prosecution. And that tells the jury of, hey, this trial didn't go the way I thought it was going to go. The evidence didn't come in the way I thought it was going to. So now I've got a secondary theory that I'm going to latch onto and try to sell you on that, even though that wasn't one of my main talking points when I outlined the evidence for you, which is the purpose of an opening statement. And that's a little bit of a concession. It doesn't mean they can't win on that. And you heard, and I've even heard you talk about this recently, Dana, about, well, if he brings the gun, he loses the ability to claim self-defense. Well, it's not bringing a gun. That you and I would be in trouble on the use of self-defense, because
it's an attack of all concealed carriers for sure,
absolutely,
or anybody
absolutely.
who carries.
Yeah, but what he's trying to do is he's trying to shoehorn the idea of bringing a gun to a situation like this protest, this riot, into the legal argument that is a correct statement of the law. It's true here in Indiana where I practice. It's true in Wisconsin, that if you provoke the unlawful action, then you can't claim self-defense. So now simply having a gun in that context is provocation. That wasn't the theory of the prosecution going into this case, but suddenly it's their main argument and closing argument. I think jurors will take note of the fact that that's suddenly a new, if not a new argument, a new focus for the prosecution, and that doesn't, I think, bode well for how they evaluate their own case.
And to your point on this, Guy, talking to our friend Guy Relford, a Second Amendment attorney, he's handled cases like these. You hit up on something incredibly important with that in those closing arguments, because the idea that simply possessing a firearm, especially I hear this a lot with people who criticize those who open carry, that lawful open carry, even a rifle slung across someone's back, is somehow by itself a provocation. And I think that's such dangerous territory, because we're hinging the validity of a natural right on whether or not someone finds it provocative. How is that sound legal argument?
Well, no, exactly. And the bullet, or the PowerPoint slide that he put up, the one bullet point said, you can't claim self-defense if you brought the gun. And I read that, and I would have loved to have been in the courtroom to see the faces of the jurors, because I would really hope that at least a few of those jurors seeing that bullet point had to do a double take and say, what? Lawfully carrying a firearm is somehow now something that makes me relinquish the ability to use force in self-defense. My goodness, why would any of us carry a gun if that were true? Obviously it's not, but it shows a little bit of desperation, if not a lot of desperation in my mind. And I thought that was very telling yesterday. It was something that I was pointing my finger at my computer screen saying, you just shifted your theory here, which means you're not in love with your own case, the way you outlined it at the beginning and the way it came in through even witnesses and evidence that the prosecution put in.
Yeah, it seems like they weren't very confident on their original argument. You were talking about the jurors, seeing the faces of the jurors a moment ago, Guy. We've heard stories about people, well, not heard stories, there's videos of people threatening to dox the jurors. Apparently there was someone who was filming the jurors as they got on a bus, and that video had been taken down. We have these stories of the National Guard, 500 members of the National Guard activated in anticipation of this verdict. And yet we have an unsequestered jury, which is mind-boggling to me, and I'm not quite sure of the reason for that. And what does that do to any expectation of impartiality from the jury because of that?
It's scary because, jurors are humans, obviously, and they're going to have the same concerns anyone would have in terms of their family, their lives, the ramifications for their town that they live in and care about. And you really do worry about the effect that has on their deliberations, including if they even fear for their own safety and the safety of their community. That's huge. And, in any case, the default position anymore among judges is to really try to avoid sequestering jurors if they can, because it's really hard on a jury. I've had sequestered juries that went longer than this, and it's really difficult to not be able to to have your normal family life and sleep in your own bed and have a meal with your family before going to the courthouse in the morning. It's very difficult. And so judges, I think, just in terms of trying to take care of their jurors, and it's hard to get jurors to come serve. Everybody wants an excuse to get out of jury duty. I even had years ago, so when I started trying cases, we said, wow, isn't it a shame that we have to try all our cases to 12 people too dumb to get out of jury duty, which is sort of a tongue-in-cheek joke. But it's difficult to get jurors. And when you sequester jurors and you see the hardship on them, that makes it harder for the next case because, clearly people understand the burden that has on those people that have elected to serve and were chosen. So judges go out of the way to not sequester, but man, in a case as this high profile and high publicity, and with the worries about the community and doxing and potential riots again, I'm a little surprised that he did not sequester them.
Yeah, it's shocking because from what I understand, can they access social media like on their phone? I mean, what can if they're unsequestered, what can they do or not do?
Well, the instruction, and I haven't seen every minute of the trial. In fact, I haven't seen as much as I would have liked to. All he said is, anything you hear outside this courtroom is not evidence. And anything you see on the news is not evidence. Anything you hear from the lawyers is not evidence. The evidence comes in from the documents and the video and the witnesses you hear in this courtroom. I didn't see any instructions. It didn't mean it didn't happen. I could have easily missed it. Don't watch TV. Don't look at your phone. I don't know that that's realistic. I don't know anymore in today's technological age that anybody would expect 12 people to even follow that if they were instructed that way. So I think he just tells them, look, anything you hear outside this courtroom is not evidence. Only what you hear here that I allow into evidence is what you should consider. That's probably about as good as you can hope for in today's age.
Goodness. Last question for you, Guy. In this hyper politically tribal age, especially with this case, because this case isn't just about this 17, now 18-year-old. It really is self-defense on trial. And I think the next phase and whether or not we just see open carry as a provocation and where we stand as a nation, and really right or left on that too. And because the jury's not sequestered, how much do you think political tribalism is going to play into this? Because this is another downfall of this hyper-political culture. We have to question now the impartiality of the people who could be determining the fate of this young man in the courtroom today. Does that realistically? I can't imagine that not playing into the decision-making process of the jury.
Yeah, I have that concern exactly as you expressed it, Dana. But I'll tell you, it even goes the next step for me, which is if this is successful here, I worry that, in every case where there are political implications, where there's a political backdrop, that this will be an intentional strategy of people who want a particular outcome, and that is to bully juries, to threaten to dox them, to intentionally get caught videoing juror members as they're walking into the courthouse, because that's an implied threat. And I could easily see a policy adopted saying, this is exactly what we want to do. It's intentional. We want to make these people nervous because the more nervous we make them, the more likely it will be that they'll vote in favor of the verdict that we want. And that concerns the heck out of me, because I could see in this environment and some of the other tactics we've seen, the same people who are out burning cities aren't going to think twice about intimidating juries. And that definitely concerns me as someone who does this for a living.
Yeah, that's a very good point as well. Guy Relford, we'll be watching this. The jury's still out deliberating, and we'll continue coverage, and we look forward to talking with you again soon. Guy, thank you so much for your perspective. We really appreciate it.
Thank you, Dana.
Of course. So up next, we turn our attention to another major issue in another courtroom. So you remember the story about Project Veritas being targeted by the FBI and then having their privileged communications leaked to the New York Times. Well, now this may have opened up a major legal case. Our friend Harmeet Dillon is representing Project Veritas. She joins us next. Stay with us. Black Rifle Coffee Company is not your typical coffee company. Black Rifle Coffee develops their explosive roast profiles with the same mission focus they learned as military members, and they've spent thousands of hours tasting, sourcing, and perfecting coffee from across the world. Founded and operated by veterans, they know what a quality cup of coffee means to active duty troops who are away from home for the holidays. So they're committed to supporting all who serve. So with every purchase you make, Black Rifle Coffee gives back. In 2020 alone, they donated over 6 million cups of coffee to soldiers overseas, law enforcement officers, firefighters on the West Coast, medical workers during the pandemic response, and more. And this November, for every coffee purchase you make, a bag of their limited edition holiday roast will be sent to service members overseas for delivery by Christmas morning. So support the cause. Visit blackriflecoffee.com/DanaTV. Check out the freshest coffee in America. And when you visit blackriflecoffee.com/DanaTV, you get 20% off coffee, apparel, gear, and your first month of the coffee club. Welcome back. So if you've been watching, you're not a stranger to the story involving Project Veritas being targeted by the FBI. Now, of course, James O'Keefe's home was raided by this weaponized intelligence agency, and Project Veritas saw their privileged communications. This is insane. Leaked to the New York Times. It's like the New York Times knew they were being raided. Project Veritas is fighting back against the Stasi-like direction that the FBI's and DOJ, the FBI working at the request of the DOJ, have taken, and they're represented by attorney Harmeet Dillon, who joins us now. Harmeet, thank you so much for being here. This is I haven't never seen anything like this. I'm almost speechless. I mean, here you have the New York Times, which is involved in a lawsuit with James O'Keefe and Project Veritas already, leaking privileged communications about this Ashley Biden diary story. And the thing that gets me is that Project Veritas never said that they even were sure it was the diary. They never confirmed that it was. They never published any part of it. They reported it to law enforcement. They got an attorney, obviously, because we've seen some of the actions of this administration, and they kind of anticipated what would happen. And then the FBI raids them. Why are people raiding businesses' offices over someone's diary before their dad was even president?
The whole thing from beginning to end, Dana, is an absolute disgrace. And I say that as a civil rights attorney of nearly 3 decades in this country. Not only did our client, a journalism outfit for over a decade, in the normal course of business, get a tip and then evaluate it, and then after not being able to verify it, and by the way, the Biden campaign and Ashley Biden were given an opportunity through counsel to verify that this document is real. They refused to do that. And so our client decided not to run the story, turned it into law enforcement a year ago. So on election day, a year ago, is when it was turned into law enforcement. And that was the end of it until fast forward 2 weeks ago, when not only James's home was raided, but 2 days before that, 2 former Project Veritas journalists' homes were raided. And in each case, I'm very confident in saying that the Department of Justice tipped off the New York Times, because the New York Times was Johnny on the spot to ask for comment within minutes of each of these raids. No other journalism outfit was. That can only mean one thing to me. And then we had the very other troubling circumstance of the New York Times publishing privileged legal communications between Project Veritas and its lawyers days after the DOJ seizes the phones. Now, I can't say with certainty that the DOJ leaked that information to the New York Times. What I can say with certainty is that it's very troubling that the DOJ even had the tip-off about the raids to our litigation opponent, the New York Times. And so on those phones, Dana, included not just our client's source materials and information of current sources reporting on the administration, big tech, and big pharma, but also multiple legal memos and communications, including my legal memos with my client. I'm suing for Project Veritas against CNN and Twitter, and also private donor information. So all of these categories of information are probably far more valuable to the United States government than some communications about a diary they don't possess and that they never published.
And I keep thinking, we're talking to Harmeet Dillon, a civil rights attorney who's representing Project Veritas in this case. I look at the story and I keep thinking this normally would be a local law enforcement issue if it was an issue of theft or, et cetera. But you have the DOJ having the FBI executing this warrant, treating it like a federal crime. Well, if they're treating it like it's a federal crime, what federal crime are they responding to?
So, excellent question. We have a search warrant that the DOJ got from a federal judge. So they privately told something to a federal judge. We do not know what, because the application for a search warrant prior to any kind of criminal indictment is not public, and we don't get a chance to review it. We don't know what they told the feds, but Tom Cotton, Senator Cotton, has asked the DOJ to disclose that information, as has a not conservative journalism organization. The Reporters Committee for Freedom of the Press has filed a motion in our case asking the DOJ to disclose what grounds they used. Because, Dana, not only is it obviously not a federal offense here, if any, and nobody's been indicted and we haven't been given notice that our client's under investigation, but more importantly, the DOJ has very specific guidelines that govern this type of situation with respect to journalists. This DOJ put out a memo in July of this year saying that they're going to change tack from prior administrations, and they're not going to issue search warrants or subpoenas to journalists other than in cases of somebody about to be killed or evidence that the journalist themselves was involved in a crime. I don't think they have that evidence in this case. I feel very confident to say they don't have that evidence. And so why did the DOJ ignore its own guidelines as well as United States Supreme Court precedent that says that it is actually perfectly legal for a journalist to publish stolen information and stolen materials? I mean, look at the Pentagon Papers, look at all of the leaks out of the Trump White House. All of that is stolen information, and nobody came with a battering ram and 10 FBI agents to Maggie Haberman of the New York Times' home, or any of the Washington Post reporters, or Brian Stelter's home, or any of the other liberals who have published stolen information. So the double standard here is troubling, but more importantly, this is a civil rights issue. Our clients' civil rights have been violated, and as soon as we get the subpoena situation cleared up, that's going to be the next step.
There's something, Harmeet, that you said that stuck out to me, because when the knowledge of this from a tipster came to Project Veritas, this was a year ago, around the time of the election, and then the raid was just recent. Now, I don't know the ins and outs of all of this. I'm not, I'm not an attorney, and I don't know how or why the FBI or DOJ would operate this way. But that seems like a pretty big gap of time if they were so concerned about it that they would escalate it up to that kind of level and have an FBI raid. Why did they not do anything for a year?
There's two theories here. Number one is they may have had a grand jury investigation open for some time. We didn't know about it. And also, I don't know what Ashley Biden said or reported to the law enforcement about the situation. I have no idea. We have no way of knowing that. But it is kind of odd that, a year goes by. There's nothing urgent about it. So typically when you're talking about a search warrant, particularly on somebody with a higher degree of protection, like either a lawmaker or the media, that typically has to be cleared at the main justice headquarters, not at the lower level of the Southern District of New York. Secondly, you execute a search warrant as opposed to getting information by subpoena when you're able to prove to a court that somebody's going to destroy some evidence. Now, you execute a search warrant on a Tuesday on a Thursday on two Project Veritas employees or former employees, and then 2 days go by before you execute it on James O'Keefe. What happened to the surprise there? So there's actually no surprise. There's no evidence that our client would have destroyed any evidence, and in any event, they've been investigating it for a long time. So these are some of the questions that Tom Cotton has asked in his letter, and of course the members of Congress have oversight authority over the workings of the DOJ. Just today, there was a hearing in camera, a private meeting with the FBI director, Christopher Wray, and members of the House, and Devin Nunes was part of that questioning. And so they asked about this very issue. We don't know what was asked because it was behind closed doors, but we may see further information coming out from Congress or information requests about this. Look, when you're talking about juxtaposing this situation, to me, a gross abuse of the FBI's power, with today's news that the FBI is being used to investigate parents called them terrorists, in violation of what Merrick Garland testified before Congress, where he told Congress that they weren't doing this. And in fact, a whistleblower has come out and pointed out that they actually are tagging journalists as domestic terror, not journalists, but parents as domestic terrorists. I think this is incredibly scary. And regardless of your politics, every American who believes in the Constitution should be very, very worried about this. Now, in our situation, the ACLU did come out with a, sort of backhanded statement, but a strong statement at the end saying that unless the government has evidence that James O'Keefe stole this diary or was part of the theft, they have no basis to do this. And so are the other journalism organizations that are coming out. So I'm proud to see that as a civil rights lawyer, but really every American should be very worried. If I criticize the government, maybe not this government I like, but the next government, am I going to have the FBI at my door? That's completely un-American.
Right. Completely agree. This is not well for, does not bode well for civil liberties, and that's a great point too about that whistleblower case with Merrick Garland. Using the FBI to look at parents who are criticizing what's happening in schools and with their school boards. Harmeet Dillon, thank you so much for joining us on this and giving us some insight. We're going to be watching as this all unfolds, and hopefully this can be resolved. I'm very happy to see that at least the sanctity of the free press still matters to certain organizations out there. So good on them for speaking up. Thanks so much. Good to see you.
Thank you, Dana.
Of course. Weird times in which we live in. Goodness. All right, so coming up next, show me your papers. This isn't Nazi Germany, but we're starting to see some parallels. We'll tell you where, what, and when next. Thanks to Biden's economic policies, job numbers are still abysmal, just like they have been every day of the week that we've talked about this. Inflation is skyrocketing, and instead of following the former president's pro-business agenda that had the economy booming, Biden wants to tax corporations and pass trillion-dollar bills that we can't pay for. It's time for you to take proactive steps to protect your wealth and retirement by investing in gold and precious metals, and Legacy Precious Metals can help. Washington continues to print money to pay for their outrageous bills, but that just simply devalues your dollar. Gold offers a hedge against inflation, and as the dollar gets weaker, gold gets stronger. The folks at Legacy Precious Metals are the gold standard when it comes to investing in precious metals, and they have a team of experts who can counsel you on the best options for you and your family. Don't leave your retirement to chance. Call Legacy Precious Metals at 866-580-2088 or visit them online to download their free investor's guide full of useful information at legacypminvestments.com. We've come a long way from 15 days to slow the spread, and yet we seem to be no closer to the end of the pandemic. And 2 years later, there's no talk of the pandemic ending, like ever. 15 days to slow the spread has become indefinite mask wearing in many places, periodic lockdowns and shutdowns all across the world, and movement passports that are really vaccine passports. They call them vaccine passports, but it's a movement passport in places like New York. And that one jab turned into 2, which turned into 3, and now it's turning into 4. First, it was the most vulnerable were supposed to get prioritized for injection, and that made sense. Now, the virtually invulnerable to the virus, 5-year-olds, it's demanded that they get the injection. An injection we have no long-term studies on. Governments have seized on the pandemic, Xi Jinping style, because it's his policy, as a way to increase their power at every turn. And freedoms, rather than returning, they're vanishing and they stay vanished. Like being able to shop without having to show the police your vax paperwork. For real, watch this video from Austria. This is the vaccination police searching for violators of Austria's unvaccinated lockdown policy. I know, right? In Austria, you have to get vaxxed or you get locked down. That went into effect just yesterday. It's a disgusting policy. These are some statist politics. We've seen this. This never ends well. And from the beginning, we told you where this was leading. I mean, this whole thing was based upon Xi Jinping's policy. That's what they pushed through Imperial College, right? I mean, we could go on about that. If you make safety the most sacrosanct value in society, then taking away people's freedoms becomes acceptable, including locking the unvaccinated down, locking them down, not even allowing them to go shop for food. I mean, you have to remain safe, right? There's this idea that somehow freedom means you're completely guaranteed to be free from any kind of risk, and that's a lie. Anthony Fauci shares this mindset. When you listen to him, personal freedom isn't even a consideration. Fauci thinks safety is the only value worth preserving and pursuing. Listen to him in this new interview with CBS.
Well, one of the things that to me was most difficult to accept is that we put together a good plan for how we were going to try and dampen down the spread of infection early on, thinking that that was accepted by everybody. And then The next day, the president's saying, free Michigan, free Virginia. I didn't quite understand what the purpose of that was, except to put this misplaced perception about people's individual right to make a decision that supersedes the societal safety. That, to me, is one of the things that I think went awry in all of this.
My first thought was, why is he wearing 3 shirts? See, for the cult of fear, safety is the only priority, and the trade-offs involved to achieve safety are not up for discussion. It never enters the mind of people like Fauci that if we have to lock down and take people's livelihoods and inject 5-year-olds with stuff that they don't need, hey, it's all right, we're safer. If suicides are up from the lockdowns, it's okay. If drug use and alcohol are up because of the lockdowns, it's okay. If kids miss out on months of school and we can't see the faces of friends or adults, that's okay. If adverse reactions occur like myocarditis, pericarditis, that's okay, because we're all collectively safer. And if it takes the vaccination police walking through boutiques in Austria like stormtroopers, so be it. Safety's priority. This is pretty authoritarian, and we decided to prioritize, and by we, I mean everyone who's not me and a lot of you watching, to prioritize safety over living. Freedom's a double-edged sword. So what will they say that we must do next to be safe? Safe from the next virus? We went from getting some people vaccinated to now COVID-0. Or perhaps stay safe from the next emergency like global warming? And at what point are we going to realize that the pursuit of perfect safety, which is impossible, has caused us to stop living a life worth living? Freedom. It does it for us tonight. Thanks for tuning in. Good night, and don't bend the knee.